So I'll make a start, and it's 18:01, so people can just join us as we get through. So welcome everyone, and thank you for joining us for today's webinar. My name's Danny Clark, and I'm the founder of Simply People. Simply People are the fastest growing occupational health and wellbeing community in the UK. We help clients to find the right provider first time and offer a triage service to help them engage with providers. We also support providers with a range of support, skills development, and events like this. Today we are presenting disability discrimination, and the session is delivered by the wonderful Jodie Hill, who is the founder of Thrive Law. Just a little housekeeping before we get started. If you have any questions during the presentation, please type them into the question box in your GoToWebinar control panel. I'll bring them up during the presentation, and we'll also have time for questions at the end. Now, without further ado, we'll turn the time over to Jodie, our presenter today. Jodie trained as a barrister, cross-qualified as a solicitor, and founded Thrive Law in 2018. She is the founder and managing director of multi-award winning Thrive Law, which is headquartered in Leeds City Centre. Jodie specialised in employment law throughout her career and has a keen understanding of this complex legal sector, together with all HR related issues. Welcome, Jodie. I'll hand over to you.
Awesome, thank you so much. So what I'm going to obviously discuss today is disability discrimination. I'm going to take you a little bit through the law, but I'm going to try as much as possible to give you some case studies so that you can really see how that might manifest itself in the workplace. So if you think I'm going too quickly, or you want me to clarify any of the different types of discrimination that I'm talking about any further, please do pop a question in the chat box, because this is your time. You've got a whole hour to go through this. I can talk about disability discrimination till the cows come home. So it's something that I specialise in. I'm in tribunal on a pretty much daily basis, talking about all types of disability discrimination, both from a mental health perspective and a physical health. So I can see how the mistakes in the workplace transpire in tribunal and how employers get stuck. We also support businesses with HR, so we actually try to really focus on the proactive side, so managing things like reasonable adjustments, which I know there's another event on in a couple of weeks' time. I think, Danny, I don't know if it's next week or the week after. So I'm not going to talk too much about couple of weeks. Sorry, yeah. Couple of weeks. So I know that we're going to do a specific session on that, because there's loads we can talk about for disability discrimination. So what I'll do, I will take you guys through the different types of discrimination that are relevant, save for the reasonable adjustments. And like I said, if you've got any questions, ask away. I'm here for the next hour. That's me. So the key thing for me is really for me to explain to you guys is for you to understand that the disability discrimination comes from the Equality Act. Now, this is not a legal test, and I'm not going to test anyone at the end, but it's really helpful to actually look at the law, even if you're not a lawyer, to see how it applies. And I say this to my staff all the time, even though some of them are training to be lawyers, but even those that aren't, it's really helpful to understand what it means. So if we look at, I'll go through the different sections of the Equality Act and explain the relevance shortly. But the key thing that employers need to be aware of when it comes to disability discrimination is that everyone, whether they're an applicant for a job or whether they are an individual who is in the workplace or for however long they've been working for, they are protected from discrimination. That's either in the recruitment process, the application process, or during the workplace. That can also be if they are at an event that's not in the workplace, but during the course of work. So again, you need to be mindful of reasonable adjustments and discrimination when you're putting events on that might not be physically in the workplace. So for example, that might be like team events, or it might be away days, that type of thing. So it applies everywhere. You don't physically have to be in the office. And the reason I say that is important because employers often don't understand that it's day one or before day one, right? It's, you've got that right from the beginning, right when you're applying for a role. And it's important because when you're applying for a role, you may or may not disclose that someone has a disability. The pre-employment questionnaires have been abolished, so there's no legal requirement for employers to ask the questions around do you have a disability and all that. The only reason employers should be asking those questions now are to make adjustments. So you need to be really careful at that stage. And then obviously if they have a disability and then are not selected for a role, then that could amount to disability discrimination, which I'll come on to. So The different types of discrimination I'm going to talk about today are direct, indirect, harassment and victimisation. So direct is found in section 13 of the Equality Act, indirect is 19, harassment 26 and victimisation 27. Oh, I'm testing myself here. But the reason I go through the Act is actually it is really helpful to look at it. And I know sometimes some of you may have never read a piece of law and really don't want to, but actually it can be really helpful in the application if you're trying to see if there's any risk. I'm going to come on to all of these areas again in a second in a bit more detail. When it comes to discrimination itself, disability is one of 9 protected characteristics. So it's again important to understand that there are these other protected characteristics when it comes to discrimination. And again, all of the protected characteristics are protected throughout employment from day one and at the point of the recruitment process. Obviously, we're just focusing on disability though. So we're going to start, before we go into the types of discrimination, I'm going to talk about, well, what is a disability? So a disability is a physical or mental impairment that has a substantial or long-term adverse effect on the individual's ability to do their normal daily activities. So that's in section 6 of the Act. And I'm going to break that down to tell you what that means. So I think it's clear what physical or mental is. So we've got the differentiation. It doesn't have to be a diagnosed condition. You just have to show that there's something physically or mentally impaired with the individual. When we talk about substantial, we're looking at realistically something that is more than minor or trivial. So it might be that it's well, first of all, it has to be to last at least 12 months or likely to last 12 months, and it has to have an effect on them on a day-to-day basis. So with a physical impairment, if someone is in a wheelchair, that's a really obvious way to illustrate that they meet the definition. If someone has a mental condition, now it doesn't always meet the definition, and this is something I'm going to spend about 5 or 6 minutes on, because mental disorders vary between individuals, and just because someone has a diagnosis doesn't mean they're caught under the disability definition. So with mental impairments, I do think it's much harder to establish whether or not they are caught, and there's a couple of things that I think are really important to consider. The first thing is, how would they function if they weren't on medication or in therapy? So think about, the individual might seem to be functioning okay, but are they dosed up on a lot of medication? If that's the case, and they're likely to have suffered for at least 12 months, then they are likely to meet the definition. Now, it's a legal test that a tribunal will determine, so it's very much up to the judge. But I do a lot of cases around mental health and discrimination cases in the tribunal, specifically looking at this point. And the substantial impact, even if someone has been suicidal, is important. But then if they don't meet the long-term element of it, as in they were like that for 6 months and it's not likely to reoccur, then it doesn't meet the definition. So it's really important that individuals understand from their perspective whether or not they meet the definition in order to get any reasonable adjustments, but also from an employer's perspective, because if they do meet the definition and you don't make adjustments, then you could be liable for claims of failure to make reasonable adjustments and other forms of discrimination. Now, we found in the past where somebody has been diagnosed with a condition that the fact that the diagnosis is irrelevant. That's one of the things the judge always says. It's irrelevant. It's about the impact on that individual, on their ability to do daily activities. So one of the things that we always ask if we're representing an individual to do is to write down the things that they struggle to do because of their condition. And that helps us to evaluate whether or not the impact is substantial or not, and long-term or not. So as an employer, you don't necessarily need to go to a doctor and get lots of evidence. You can make a judgment on this without all of that, because it's not subject to medical evidence. It's subject to you understanding as an employer what the impact is of the disability, whether it's mental or physical, on their ability to do their day-to-day activities. The other thing I'd say about daily activities is it's not just work. So it might be at home, they can't wash, they can't clean, they can't get upstairs, they struggle to concentrate, they can't sleep. Lots of different things, and everybody's affected differently. So make sure you don't assume whether someone meets the definition, and actually do a little bit of investigative work to understand whether they meet it on all of these counts. In terms of the long-term element, if I've mentioned a couple of times, if it's likely to last more than 12 months. So don't just write someone off because they've only suffered for 2 months, 3 months. If it's likely that they are going to continue to suffer, which often happens with many disabilities, it's often more than a 12-month period of time, then they're likely to be covered by the Act. So again, it's just making sure you're acting in accordance with the definition and not just on a diagnosis. I've popped on there that cancer and MS are automatically disabilities, and what that means is they don't have to show what the impact is or the longevity or the substantial effect. If somebody has a cancer or MS, they are automatically disabled, and you go straight on to the next stage, which is either making adjustments or evaluating if there's any other risk in terms of discrimination. In terms of knowledge, again, all of this is great to understand, but if we don't have sufficient knowledge as an employer, how can we be expected to do anything about the disability, whether that's put adjustments in place, or if we dismiss them, how could we have dismissed them because of disability when we didn't know about it? So knowledge is important. If you have any knowledge, whether that could be a physical document, whether that's a sick note or an occupational health report or any other physical document, it's likely to impute knowledge. However, only knowledge of a diagnosis or impairment, not necessarily the daily activity. So you need knowledge of the whole disability is the first thing. The second thing is really understanding whether or not the employer reasonably ought to have known. And this comes up quite a lot where somebody, I don't know, maybe having a performance issue, they may then go off on long-term sick, and all of that was because of, I don't know, depression or anxiety. And there was a case not that long ago where somebody was dismissed for that capability. It was a fair dismissal. They weren't performing, but that dismissal was actually a discriminatory dismissal for disability. And the reason for that was because the individual had clearly been struggling. There was indications in the workplace that they weren't mentally okay, but they hadn't explicitly told their employer, nor had they given them any evidence. But what the tribunal said was actually what they should have done here was investigate it as part of the dismissal process or the capability process. So whilst the dismissal was fair under the Employment Rights Act, it was discriminatory under Section 15 of the Equality Act. And that was really a bit of a shift over the last few years, where we've seen a rise in Section 15 claims, which I'll come on to. But the point of me telling you that story at this point is really because that employer were like, well, we didn't know. And the tribunal said, well, you ought to have known, because they weren't, you know, it had come from nowhere. They talked to people within the workplace. Yes, you didn't have physical documents, but you didn't investigate the point. You didn't investigate why they were not performing. And that's how a lot of employers get caught. It's very rare that an employer will say, oh, you have a Disabilities Act. It's normally a nuance that's related to performance or long-term sickness absence or an adjustment that's needed. So the imputed knowledge is really important to know about. First of all, a lot of employers are unaware of this structure that you have to go through from an individual's perspective. If they're bringing a claim, they have to basically prove that they are disabled. They then have to also identify the date in which the employer knew or ought to have known of the substantial long-term adverse effect on their day-to-day activities. So there's a real onus on individuals, first of all, to put their case. And then secondly, once they've crossed that threshold, it's for the employer then to explain the real reason why they were dismissed or whatever happened in relation to the discrimination. So the burden will shift once they've established that prima facie case. So this element of it is important, not just for the employer to know about, but for individuals as well. They have to establish that. Okay, so disability discrimination so if we talk about direct discrimination is where someone's treated less favourably because of their condition, because of their disability. Now that's, in my experience, really rare. I very rarely come across somebody saying you have a disability, so this is happening to you. What's more common is indirect, where there's a policy, procedure, requirement in the workplace that applies equally to everybody, but places someone with a disability at a disadvantage. So a really easy example of that might be a requirement to go into the office up some stairs. That places someone who has a physical impairment, that means they can't walk, at a substantial disadvantage. And if adjustments aren't then put in place, which we'll come on to, that could result in a claim. So when you're looking at indirect discrimination, it's not because there's any intention, it's not because anybody wants someone to feel that way, and there's no motive required. It's simply that the way that the policies or procedures work indirectly put somebody from either from any of the 9 protected characteristics, but in our case today, anyone with a disability at a substantial disadvantage. So another example of indirect discrimination might be regarding like a performance process and the trigger points, and someone who has a disability is more likely to hit those trigger points sooner rather than later, which may result in dismissal. So part of that process would be, again, to look at adjustments. And like I say, in fact, we've got the date there when the next one is. So when we talk about adjustments, we'll go into a bit more detail of how that would work. But they link it, the process for indirect discrimination and reasonable adjustments is really similar. Both of them require the individual to identify a provision or a practice within the workplace that applies equally to everyone, that places them at a disadvantage. Now, indirect is there where there isn't a reasonable adjustment that's relevant, and where there is a reasonable adjustment that's relevant, you would bring the claim under the reasonable adjustment legislation. So hopefully that makes sense. I feel like I've rattled through indirect. It's not easy to understand, and I know a lot of lawyers that still get it wrong, but hopefully it gives you a bit of insight in terms of how it can be, the most innocent thing that you're putting in place in the workplace that could actually, through no fault of your own, become an indirect claim. Now, with direct discrimination, you can't defend that type of claim if it's a disability one. If it's found that the company have directly discriminated against, it is discrimination. If it's indirect discrimination, however, there is a defence. And the defence is you have to show as a business that you are trying to do that to achieve a legitimate aim. So it's looking at proportionality and balancing the needs of the entire organisation and everybody else, the reason for that process or requirement being in the workplace, against the individual who's at the substantial disadvantage. So again, if you are going to put a policy in place that you think might be indirect, then indirect discrimination, you do need to objectively justify why you're putting that in place, and make sure you have a paper trail, because if you can do that, if anything arises out of the new policy being brought about, you've then got a paper trail in which you can rely on to support any defence if it comes to that. But all of this that I'm telling you now is really about being proactive and trying to avoid claims. Obviously, no one wants to end up in the tribunal. But the most common claim that we're seeing at the moment is the arising from disability. So this is the Section 15 claim that I talked about before. And this is where, and I suppose the best example of arising from is where somebody is dismissed because of their long-term sickness. Their long-term sickness arises as a consequence of their disability, and therefore it's discriminatory unless it can be objectively justified. So again, there is a defence if you can go through that and justify. So I don't know, they say they've been off for 12 months and actually there's no prospect of them coming back, then you could potentially defend that type of claim. But where there are no reasonable adjustments explored prior to dismissing someone for performance or capability, it's likely to be a disability claim, not just for failure to make reasonable adjustments, but also arising from disability discrimination. So that's the Section 15 one that I was talking about before. That's the one that catches everybody. I think generally businesses need to function, and they're trying to work out what to do with a potentially disabled person, and they either get caught because they don't think the person is disabled, or they deal with it just under the Employment Rights Act rather than the Equality Act. So it's just being mindful that you've got these two bits of legislation that run side by side, and whilst you have to make sure the dismissal is fair, which is a whole of the webinar, you also have to make sure it's not discriminatory. So yeah, that's hopefully explained in enough detail what those are. And as I said before, we are going to talk in much more detail about reasonable adjustments, how to go about that, what you need to do, what's reasonable, what's not reasonable, because it definitely needs its own webinar, because there's an awful lot that we can go through. And I'm also going to bring a couple of case studies as well. One interesting area of disability discrimination, which in fairness doesn't come up that often, is association with a disability, where someone is discriminated because of that. So it could be, I mean, I put on the slides about impact of shielding, and the reason for that is where somebody is, we've seen it quite a lot recently, it's not transpired as a claim, but we've been advising on it. And essentially, where someone is shielding, they're likely to have a disability because they're in a high risk category. It doesn't mean they definitely do, but ordinarily people who are shielding have their, have a condition that's either a physical or mental impairment. It has a long-term adverse impact on their ability to do daily tasks. So they're likely to meet that definition. And where someone is shielding and wants, I don't know, to be furloughed, say their partner's shielding, and so they want to be furloughed, so they're not going to and from a factory or an office. If you refuse that, there's a risk that there could be a discrimination claim there. So it's really important to consider if anyone has an association with a disability. There was a case a couple of years ago where somebody asked for I think she'd asked for not reasonable adjustments, sorry. She'd asked to work in a certain way in an office, and it was refused. Sorry, other people had been given the opportunity. Excuse me. Sorry, guys, we've just got a frog in my throat there. Other people had been given an opportunity to do this, and she was refused, but she was refused because of association with her disabled son, and she needed to work in a certain way. It wasn't a reasonable adjustment. Other people were working in that way, but she was specifically refused, and it was identified she was refused to work in that way because of her son being disabled. I think they'd said that she couldn't do a job and care for him at the same time, or something like that. And she brought a claim for associative discrimination. So this is where an individual doesn't have the protected characteristics, she doesn't have the disability, but she's been treated in a way that amounts to indirect or direct discrimination because of her association with her son. So it's often in caring situations that it comes up. And obviously, as I've alluded to, the shielding situation at the moment, we're finding that it's a bit more topical because people are having to make requests to work in different ways because of that. It is important to note that reasonable adjustments don't apply when it's an associative discrimination. So it's only the indirect and direct claims that we talked about before. So it's quite niche, and as I say, it very rarely comes up, but it's something to be mindful of when you're considering things within the workplace or refusing to do something for someone. Are they asking because they're associated with a disabled person? And if so, is that something that you need to consider as part of your risk management in terms of whether or not they'll bring a claim as a result, especially if it ends in a dismissal. Okay, so what to do when, I mean, there's a bit of guidance here for individuals on the slides, but also I think from an employer's perspective, if you have any indication that somebody is disabled, or you think that you're going through a process and you're thinking it's a performance thing, really go into a bit more detail. Don't just go straight to the, I find often what can happen is you go straight to the end point. It's a fair reason, it's capability. So really do have a think about the way in which you approach someone who has a disability. And even if you don't think they have a disability, treat them as though they do, just in case it transpires that they do have a disability later. So I think always err on the side of caution. And actually, it's the right thing to do. If somebody's saying they're struggling and they're asking for help, surely it's in everybody's interest to make adjustments or to ensure that they're not treated less favourably because of that. So I think from my perspective, there's a moral standing there, but also it's in everybody's interest. It's a win-win to support people with disabilities from the outset. If there is any form of complaint, whether that's informal, formal, or an actual grievance that's lodged or a claim, make sure it's dealt with in writing. Make sure you follow all of your own processes, and make sure that the individuals who support anybody as part of that grievance process are not subjected to a detriment. So on one of the earlier slides, I'll just go back to, we talked about, I think it was on the first one, victimisation there. So victimisation is effectively what I was just explaining there, where somebody supports an individual with either a grievance or a claim, either as a witness or otherwise, and that grievance or claim talks about a breach of the Equality Act. Now, if the employer then treats them in a way that results in a detriment, so that could be excluding them, dismissing them, demoting them, or for whatever reason they suffer a detriment because of that, they are protected even though they don't have the claim. So any victimisation is a really, really important aspect of discrimination that people often get wrong. I know individuals will say, I've been victimised, and they talk about it in a way that actually doesn't fit within the legal framework. The legal framework is really clear in that you have to have done a protected act, which was the grievance or the tribunal claim. That protected act has to talk about a breach of the Equality Act. And then the individual is either the person who's raised that complaint or somebody who's supported it. So everybody involved is protected under the Equality Act under Section 27, and that's called victimisation. So that's, again, another type of discrimination that's important, and especially so when you're going through grievances, make sure they're dealt with in a way where nobody suffers a detriment as part of that process. And actually, I've realised that I haven't talked about harassment. So before I go back to that other slide, whilst I'm here, I'll briefly touch on harassment. I think harassment's a really easy one to identify. It's where somebody either says or does something because of their disability. So they might make fun of them. Often you find things like people say, oh, I'm so bipolar, or you're so on the spectrum. Like they'll say comments that are offensive to that person because they have a disability. So harassment, I think, is first of all something that employers often call out very easily because it's clear what it is. It's usually linked with direct discrimination, but actually harassment has a slightly different definition, because direct discrimination is less favourable treatment because of the disability. Harassment is words or conduct that have the purpose or effect of violating the dignity or offending them in a way that that causes harm and injury to their feelings. So the types of claims can be actually pleaded in several areas out of the same facts. But harassment, in my view, is something that is still really common for disabilities. And I think it's actually really sad that people still think it's appropriate to make jokes out of people who have a disability. But believe me, that it's still coming through the tribunals, which is really shocking. And the other thing about harassment is there's no intent needed. So even if you're saying it in a way that's, oh, I'm so bipolar today, somebody who is bipolar and is offended by that could be harassment, and the employer is liable for that even if they've not condoned it. So it's really important that businesses approach disability discrimination and all types of discrimination in a proactive manner, because explaining and educating their staff on all of these areas where they actually, some of those things they might not think are discriminatory because it's not off the bat discriminatory because that's what they're intending it to be, but there's no intention required. And I think that's really important to remember and actually educate people on, especially where the employer is then vicariously liable for their actions. Now, when it comes to a claim, the employer could be liable for all of the actions of some of their staff, but the individual can also be named as an individual respondent. And that's unique for discrimination, not just disability, for all types of discrimination. But an unfair dismissal claim would ordinarily be brought against a company, and that's it. And the company would be liable for anything that happened with their managers and anything that happens with the team. But with discrimination, the employer can be listed alongside an individual. So again, part of the reason why I talk about training is, individuals can end up personally liable for damages in tribunal if they're liable for any of these acts of discrimination. Now, when I talked before about the defences, the employer can bring the defences for the different types of discrimination that I talked about, apart from direct. What they can't do is, unless they can show, so say for example, I don't know, Bob Bob discriminates against Jill, and then Bob is named as a respondent along with the company. Now, Jill might want both of them on there, but the company might be able to argue that actually they're not liable for the actions of Bob because they can invoke their statutory entitlement. There's a defence under section 109, and effectively what that means is that they've done everything as a company to prevent the harassment or any type of discrimination occurring, and this can apply to any type of discrimination. So it's called the statutory defence. And again, it's important that individuals and people in management roles understand this, because this is why the training is important. This is why your policies are important, and this is why embedding this into your culture is important. Because if you can show that you have provided sufficient training and you've made it really clear that you're anti-discrimination, anti-harassment, pro disability, then if somebody then does one of these things that you've categorically trained them not to and told them not to, then you may be able to remove any liability from the company and push that onto the individual. And that can be significant because these types of claims can be really expensive. So it's important for businesses to be really proactive when it comes to disability discrimination. The last thing you want is to be in tribunal, because they're uncapped claims, and people can claim, you know, several years loss of earnings. So I've jumped to tribunal. I knew I'd jump ahead. So with the tribunal, the claim has to be brought within 3 months. So if it's the same with any type of discrimination, again, if you are going to be in this situation, the first thing you need to do is take advice to make sure you properly defend it, because each type of discrimination is dealt with in a different way. What we find is employers that try and do it themselves actually end up in a worse position. Even if you just get the solicitor just to do the response and advise you on what prospects you've got, that's the point that you really need the most support, because that's the most important document, is your ET3 that goes in to defend that claim. Now, you'll know about a claim before it goes in, because the employee has to engage with ACAS early conciliation. That's a mandatory next step when you go through tribunal, and all claims have to go through that process. So provided they've done it within 3 months, that claim should be within time. ACAS does pause the time limit. So when you're in ACAS, the time limit is effectively frozen until it comes out, and the employee will then have at least 1 month from the date of the certificate being issued to issue a claim. So it's a bit more difficult now to kind of work out, are they still going to put a claim in? Because we don't always know when the certificate's issued, because the employee gets the certificate, not the employer. So it's one of those that if you think a claim is coming, just make sure that you have everything documented, and you've got a file of everything that's ready to review, that's relevant. So whether that's, you know, medical documents regarding reasonable adjustments, or anything regarding sickness, absence or dismissals, all of that needs to be kept safe, so that you've got that for the tribunal. One of the things that does happen if people are not treated properly and they think it amounts to discrimination is that they can resign. Now, if they resign in response to discrimination, it could give rise to a constructive dismissal claim. So you've got a double-barreled claim there, where you've got someone claiming injury to feelings, but they're also claiming constructive dismissal, which is effectively an unfair dismissal claim, but where they're forced to resign. So acts of discrimination are enough to justify a fundamental breach, which would justify a constructive dismissal claim. So again, what we find is where employers are really reluctant to give reasonable adjustments, or they suffer any form of harassment in the workplace particularly, then it can damage the working relationship to a degree that they actually feel that they can't work there anymore and resign. So again, really important to consider the possible risks of not getting it right. And it's not to scare people at all. Most organisations don't ever get to that point, but it is also important to understand that there are these risks out there, and that people can resign in response to allegations of discrimination. Oh, any questions? And I'm at the end. Has anyone got any specific questions, or would like me to go over, because I feel like I've spoke really fast. So if you'd like me to go over any of the areas of discrimination or give more case studies or anything, let me know, and I will take some questions. Danny, have we got any in?
Yeah, there's a few questions, Jodie. So thank you for those that have asked the questions. Thinking of returning to the workplace as COVID restrictions relax, Where employers force employees to return, could this be indirect discrimination where they are aware of long-term anxiety? Reasonable adjustments such as hours working from home then put in place.
Yeah, so yeah, that's certainly something that's coming up at the moment. So what we're suggesting is everybody needs to go through an individual risk assessment, and if part of that is linked to a disability, then you need to consider what adjustments you can make. Now, like I said before, we're going to do a whole session on what adjustments are reasonable, but essentially what you need to be looking at is, what can they do their role in another way? Is there any other way that they can reduce the anxiety? Will them working from home actually reduce the anxiety? What's causing it? So again, a lot of people will be feeling anxious, but is it a disability? I mean, I personally have anxiety and PTSD, and ADHD, so I know what it's like to have a disability. But equally, just because someone feels worried doesn't mean that they are disabled. So again, going back to that definition, establishing whether or not you think they meet the threshold, but equally looking to see if there's any way you can support them. And if you can make adjustments, make them. If you can't make adjustments, then make sure you can objectively justify why. And that's the key thing, is that if you're going to refuse anything when a potentially disabled person asks for it, it's essential that you have a clear paper trail of exactly why that's being refused, so that you can justify it if they raise a grievance or worse, bring a claim.
Perfect. John, I know that you've asked a question, what is it about Employment Act which is less than Equality Act? But I'm not sure what you mean by that. So maybe you could put another question in just to clarify that, if you don't mind. We have another question.
I think it might be. I think I might know what he means. So the Employment Rights Act requires, if you want to bring an unfair dismissal claim, you have to be employed for more than 2 years, whereas an Equality Act claim has no length of service requirement. So that's what I think he might be saying. What's the difference between them? I hope that's answered it. But ordinarily, if someone's been employed under 2 years, they tend to be the ones that end up with disability discrimination claims, because the employer's thinking, oh, well, I don't have to go through the process because they're not going to be able to sue me for unfair dismissal, but they forget about disability discrimination. And then that's when those claims come in. So that's like the high risk category, where they probably aren't going through a normal process or a proper process, because they're not thinking about the risks that they obviously would ordinarily need to consider if someone had more than 2 years service. So I think that's, I hope that's answered it. If it hasn't, just ask another one.
Absolutely. In the first round of shielding, partners were also told to shield, but this time the government are now saying people living with shielded families should continue to attend work. How can the use of discrimination by association be legal for a shielding case?
So where someone's shielding is only if that person has a disability. So as I said before, first of all, establish, do they actually have a disability? It's difficult. I mean, we've had a couple of cases, and actually all of them ended up in settlements, where an employer was forcing someone to come in and they were living with someone who was at risk, and especially where that individual who's being asked to go into work is having face-to-face contact. Now, if they're having face-to-face contact but it's fully COVID secure, that's slightly different. And I think it's very fact specific in terms of what are they being asked to do. If it's in an office, it's less likely to be associative discrimination, if that makes sense, because they're well, actually, look, if they're in an office, they could probably work from home. That's a bad example. But where someone's being asked to be customer facing, I don't know whether that could be in a hospital or in a shop, perhaps. If they're not wearing the correct PPE, then there could be a risk there. But again, there's health and safety stuff that goes around that as well. It's not just disability. So it doesn't mean that you have to be associated with someone. If it's not a safe place to work, then you're protected under the health and safety legislation as well.
Awesome. Next question from John again. How hurt does someone's feelings need to be to have a claim? For example, is it sufficient for something to be said, or do you need to prove that what was said caused a certain level of emotional or physical impact?
That's a really good question. So in a tribunal claim for disability discrimination, the award is injury to feelings. There are three bands of award that you can get, and it starts at, the first band is like a couple of £1,000, the middle band is up to 30 odd thousand, and then above that is the sky's the limit. And there was a case in Leeds where somebody was awarded £1 million. So they were a doctor and they had a breakdown off the back of the discrimination that they'd suffered. So in answer to your question, yes, they do have to show that there has been an impact. Part of that is through the remedy hearing. So at the final hearing, the tribunal will ask the claimant to give a statement on the impact of the discrimination. So they have to attribute any injury to feelings, as it's called in the law, to their to the actual discrimination. So they've got to link the two. So say, for example, if someone was called something offensive and that was harassment, but then they were dismissed for something that was non-discriminatory, and actually they were really upset about being dismissed, and that's not the discrimination, then their injury to feelings would be relatively low if they weren't offended by the comments, or they were only slightly offended by them. So the value of the claims is actually really difficult to quantify, because how do you quantify an injury to someone's feelings? It's very, very difficult. So the case law is really there to support, but it's very much dependent on the tribunal and the judge, which is really unfortunate. In my experience, disability discrimination claims average about a value of between £10,000 and £15,000. That's just for injury to feelings. But where there's a dismissal as well, you can also claim loss of earnings. So if someone, if someone's been dismissed and it's a dismissal that's discriminatory, then they can claim, the sky's the limit until they get a new job. So that's where the claims become really lucrative for individuals. But like I say, ordinarily, if it's just a standalone claim, you're looking at probably 10 to 15 if someone's got a significant impact. And if it's just a one-off comment or a one-off thing and there's no evidence of a significant impact, it's likely to be less than £6,000. That's an average, don't quote me on all of that, but that's my experience in doing the advocacy and being in court and seeing how these decisions are made. But yeah, it's a really good question. Thank you.
Thanks, John. Thanks, Jodie. Next question. You did not mention HIV positive employees being classed as an automatic disability. Has this changed recently?
No, it hasn't. That is another automatic disability. It hasn't changed at all, no. And it should have been on the slides. So yeah, thank you for pointing that out.
Next question. Would a contractor be covered if they're providing a service to a business?
Say that again. Would
a contractor be covered if they are providing a service to a business?
Would a contractor, like a self-employed person? So somebody who's self-employed, like a freelancer, yes, they could be covered by it, yes. So the disability discrimination also applies to the public sector. There's a public duty as well. So, for example, accessing a bus or a public building, that type of thing. So it's wider than in the employment context.
Perfect. For the employment tribunal, did you say that claims have to be made within 3 months or 3 years?
It's 3 months less 1 day from the last act of discrimination. And I'll just explain briefly what that means. So often where there's a discrimination claim, there's more than one thing that's happened. So especially where it's like performance related or something to do with a long-term sickness absence because it's gone on for a period of time. Now, the last act, so that might be either the dismissal or the refusal to make adjustments or the harassment, whenever that last act was, the claimant has to bring a claim within 3 months less 1 day. I don't know why it's less 1 day, but it is. And what that means is they've got to go to ACAS within that time, and then after they've gone to ACAS, they can issue the claim. So they've got to go to ACAS within 3 months. Now, if there's a series of claims all around the same thing, all related to the same disability with the same manager, say, then they can potentially link all of those claims together as a continuing series of acts and just use the last act as for the purposes of the time limit, and it basically brings all the old stuff in time. So there is a way to do that under the Equality Act. I think it's section 123, and effectively you can bring all the old stuff in, provided you can link them all together. But yeah, in short, it's 3 months less 1 day.
3 months. Perfect. Next question. We had a situation where an individual stated they had depression due to a particularly difficult time in their life, but did not access any treatment. She used self-management strategies. The judge said that because she had torticollis previously and had some days off for this, it equated to a disability, as the torticollis was due to anxiety. At the time of the tribunal, she was on medication, but surely the employer couldn't have known she was disabled at the time of employment.
Yeah, I mean, tribunals are making findings of this nature. We're seeing it all the time. It's about exploring it further, and it's about that investigation piece. So if you know of a condition or you suspect someone may be disabled, it's prudent moving forward to actually do that investigation internally and obtain as much medical evidence as you can. There's no requirement for the medical evidence, but then it's assessing whether or not you ought to have reasonably known. It's not necessarily that you should have known, it's that you ought to have reasonably known it because you should have done more. And that's what the tribunal is trying to get at, is they want employers to actually go a bit further than simply take things on face value.
Perfect. Next question, another one from John. I understand that a condition since recovered from is also a qualifying condition under the Equality Act. What relevance might this have for occupational health? For example, there could be nothing to make adjustments for, so is this only relevant for things like victimisation, harassment because of a condition since recovered from?
Yeah, so if they've since recovered from it, then there's a question, obviously, whether or not it actually meets the definition. So it could meet the definition because it could be a recurring condition, and that can be caught under the Act. If you've fully recovered, then it's unlikely to meet the definition of disability because you've not got the substantial impact. So there are various cases that talk about this, but it comes up a lot with mental health because it's not every single day that you have a substantial impact on your ability to do daily things, but most people will come in and out of depression or anxiety throughout their life, and on that basis it can be covered. But yeah, if they don't need adjustments, you don't need to make them. It's very much about a two-way street with adjustments. You need to ask employers need to ask employees, but equally the employees need to tell them what they need. And if they don't need anything, then it's just being mindful not to treat them less favourably, not to victimise them, and not to harass them.
Perfect. Next question. When undertaking a case management with new diagnosis of autism and was advised to see OH from Autism Society, person has a diagnosis, no medication and reasonable adjustments were recommended. Can manager all task daily care, eating, drinking, however, doesn't go into any shops as a partner does this because of social interaction? Is him not shopping part of his daily activities?
It can be part of his daily activities, but it's about substantial impact. So is there more than just the shopping? So you've got to establish what is the substantial and long-term adverse impact on daily activities. It's plural, so it's not just one thing. So if you can establish that there's more areas of their life that are impacted, then you're more likely to be able to meet that definition. One thing I would say on reasonable adjustments is that it's not always prudent to just go on what occupational health say. You need to speak to the individual. So the occupational health therapist might say actually they don't meet the definition. That might be the case, but it's a legal question, not a medical question. So whilst that they will make an informed view based on what's in front of them, it's very much up to a judge to make that decision. So when using any medical practitioners, it's just being mindful that they might not always agree that they have a disability or that they need any adjustments, but it might still be something you can consider, and judges will look at that as well. They don't like businesses, and in fact this makes it really hard for people because they go to a medical professional because they want the support and the guidance on what to do, but part of that is actually consulting with the individual and making sure that the adjustments that they might need for a role might be really simple and not something that Oc Health would have even mentioned. So it's exploring it beyond the documents that you've got and beyond Oc Health as well. And that's important.
There is a question that's very specific and individual that I'm not sure we should be asking on this webinar, Jodie. So I'm going to ask you to kind of refer to that one afterwards. And there's another question that asks about what questions would you recommend are asked on a new starter questionnaire?
Okay, so a new starter questionnaire, I ask people, I'm assuming it's about disabilities and adjustments. I ask people if there's any adjustments that they need to do their role. Do they have a disability? Is there anything that I can do to support? I ask it in a way that's supportive. Obviously my business is very focused around supporting people with mental health problems and disabilities anyway. But ordinarily, the whole purpose of the new starter form for me is really to understand what they need and also get the information I need to make sure I can support them properly. Obviously you won't have that information prior to them starting because you won't have necessarily asked them in any detail at the interview. So it's really for them for you to create an open space for them to open up about any possible adjustments that they might need.
Perfect. Thank you very much. That's the last of the questions. Does anybody have any other questions for Jodie before we close the webinar? obviously there's silence, so I thank you all for your time. Thanks for joining. I hope you enjoyed the session, and thanks so much for attending today. See you next week for post-COVID, and 2 weeks time, hopefully, for reasonable adjustments. Speak to you soon.
Reasonable adjustments. Awesome. Thanks, guys. Bye.